So now there's a difference between, so I've been constantly referring to it's the same as when you argue. If you develop the skill, then you have that skill as well. But there's a slight difference between when you're arguing in court yourself and briefing a senior advocate. I'm pointing this out so that you can appreciate what is required when you're briefing a senior. What do you actually do when you're briefing a senior? When you get that, then you will know that you need to begin from the scratch. So when you brief a senior, leading the senior, right? So he's going to speak under your instructions. So you need to be very confident about what you are doing. You need to know what you are doing and be very confident about it, right? The job is similar yet different from the judge. The judge has read the brief, has views. So the judge of a Supreme Court has read your brief. Whether he has skimmed through it, whether he has read it thoroughly, he has read it. He has some view in his mind. He has legal position in mind, right? You get to alter it if it's against you, or your job is done. That's what happens when you're arguing. Sometimes you don't even have to argue, notice issued. You go to seek a passover, notice issued, right? So you don't have to do anything if the judge is with you. You get to alter it. The judge may ask you questions, or you may sense that the judge is not with you. You know what may be going on in his mind. You address it, job's done, right? He may ask you a question, you address, he's satisfied, your job is done. The only tricky bit would be to understand how much the judge already knows and where he would need a clarification. Job. On the other hand, the senior is sitting with a blank slate. So I'll tell you how different it can be. So when I started the session, you remember how I was going on speaking, and then Abhyuday had to interrupt and start talking about what briefing actually means. So that's the difference between arguing before, because he knew that there are law students as well who may not know anything. So then you start from the scratch. So when you're briefing a senior, you don't assume any information in his head. You start from the scratch.
There was one person who actually said that a senior may know everything, so what's the point of briefing? So I said, let's do the reverse, that don't assume anything. Like as you're saying, no, that's the answer. I didn't say it. This is the answer, what Sanchita is saying, okay? And you might think that you all are students, so you all need briefing, but seniors also need briefing like that, okay? In matters. They'll pick up very fast from the Supreme Court filing perspective. They'll ask you questions which will make you stumble in matters you have been working on for years, but they need to be briefed from the ground level, okay?
Right. You can write anything in whichever form you want, and it stays more or less in the same form till the end. So that's the significance of briefing a senior counsel properly. So since you're briefing from the scratch, he does not know anything. So sometimes you take the brief along, you have sent the brief beforehand, he hasn't gone through, right? He may have at the most asked the junior what the matter is about. The junior said, oh, bail matter, right? That's it. Right? So now you can say anything, you can do anything, and that stays with him. That stays with him in the same form till the end. When he's arguing, that stays in the same form. Even in the judge's mind, it does not get changed. So in the pleadings, you may not have taken all the grounds. At the end, you say any other ground, etc. But when you are arguing, then what you utter stays. And it starts right at the stage of briefing. We think, oh, whatever the arguing counsel has argued stays in the minds of judges. No, actually, that's what the briefing counsel has already done. He has written something in the mind of the senior advocate. The job is already done, right? So that's the kind of impact a briefing counsel's job can have on the case. Style of briefing matters. Vijay Agarwal. So Vijay Agarwal was briefing us on 4G matter, and he said, "Sir, आप बस ये बोल दीजिएगा," right? And it's very interesting. It's very amusing to hear a briefing counsel brief in such a manner, because he's so confident. What will work? He's a trial court criminal lawyer, and he's very good at what he does. But he also knows what will work in the Supreme Court, and he has the confidence to tell the senior that you just need to say this. And trust me, he just needed to say that. So that's the kind of briefing counsels that you would want to make. You tend to remember what is interesting much more. So therefore, when I say style is important, I also mean that you can, just as you would expect a briefing counsel, an arguing counsel to make the arguments interesting when he argues before the Supreme Court. Right? That's one of the things. Why make it interesting? Because it stays. You get the attention of the person. You invade the person's thought process. Therefore, it's important to make it rich. It's important to make it impressive. Right. Remember the person too. So that's one of the ways of leaving an impression on the senior counsel by making it interesting. You will forget exactly what was said, but you will remember because you relished listening.